content and ready? Yeah. All right, thank you. Members, the meeting is now open to the public. Is there anybody else to come in, Brian? Do you know?
There's 4, I think, coming in.
All right. We'll carry on until they're in then. The committee's going to be recorded as usual and broadcast throughout Parliament buildings and online. Everybody in the gallery is permitted to use their mobile phone, but it should be on airplane mode and muted. Members, again, I would just reiterate that we have a number of members attending virtually. So at present we have Doug Beattie, Sinead Ennis, Justin McNulty and Ciara Ferguson. And Maurice Bradley may join us remotely also. It's proposed that the oral evidence session on the Enabling Access to Justice programme will be recorded by Hansard. Are members agreed?
Agreed.
Thank you. Also, we're obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence our approach to matters under consideration. Any member who has an interest to declare in today's business should do so now or when the particular matter arises in the meeting. Does anybody have any interest to declare? Could I declare that I have an immediate family member who works in the legal profession, please? Thank you. Agenda item 3 is the draft minutes of the meeting held on the 16th of May. So those are at pages 21 to 30 of your meeting pack. Are members content that the minutes are a true reflection of the proceedings of the meeting held on the 16th of May? Could I ask members to indulge me for a second about a couple of points? One relates to our evidence session from the Independent Monitoring Board. And in there, the minutes say that we have sought information from. I think that's a different question to what we asked. I think what we asked was what action was being taken. We didn't seek general information. We'd been given the information. It was what action was taken, and certainly that is reflected in the correspondence that was sent. Would members be content to make that change in the minutes? Thank you. In addition, there's another one with regard to the Committee of Finance. Let me just find what page that's on, which is on page 8. So the Committee of Finance, you'll recall, asked us for some information. We agreed what we would send, but we also indicated that they should be advised that we had not received a budget briefing from the department. That's not included in the minutes, but I think it's an important point for the minutes to note. And again, it's reflected in the correspondence that was sent to the Committee for Finance. Are members content that we include that in the minutes? Thank you. So if you're all happy enough then and there's nothing else, then I will sign the minutes once those changes are made. Thank you. Agenda item 4 then is matters arising, which is the damages process for setting the rate of return regulations. And information about this is at pages 3 to 46 of your tabled pack. So further to last week's evidence session on the SL1, the committee agreed to write to the department requesting further clarification on the modification of the standard adjustment from 0.75 to 1.25 and ask whether the department had conducted an impact assessment as recommended by the predecessor Committee for Justice. The department's response has now been received and you'll find it as outlined a minute ago. Do any members have anything they want to comment on with regard to that response or the issue in general? If I can kind of summarise where I think we are on it and maybe take soundings on how we might proceed. So it seems to me that there has been some confusion over this issue. We are asked two very specific questions. the department is asked and we are asked to go over it. So one is to set the index that will be used, and the other is to agree the parameter as recommended by the department for GAD, that's the Government Actuary Department, to choose the rate. So that's all we're asked to do. However, we have sought to try to understand the process. We have sought to try to understand what the implications of that rate may be, because it seems to me we have received contradictory evidence. On the one school of thought is that a potential increase will keep us closer to the 100% mark in terms of compensation. The other school of thought is that it will not, and that there's a degree of overcaution, and the implication may be an increase in insurance premiums, which I think has left us all in a difficult position of trying to understand. So, and try to make the right decision based on as much information as we can glean. The department in this response has indicated that it is not for them to, I suppose, overstep into the territory of what the implications may be for others. And I can understand that position. However, it would be helpful for us to have some understanding. We're trying to do the best that we can here and do the right thing, but I think we've struggled with it a bit thus far, and certainly what the ramifications may be, because if there is an increase in insurance premiums, that will affect everybody in Northern Ireland, wider society, and these are significant amounts of money in terms of claims and damages. So it is something that we have sought to try to get right. It is proposed, members, that we would perhaps schedule an oral evidence session next week with officials from the Government Actuaries Department to help us find a way through this, because obviously the time frames are tight. The review has to commence in July. First of all, could I ask if members are content with that proposal?
Yeah.
Yeah. I think so.
Secondly, could I ask, is my summary a reasonable assessment? And if so, what do members consider in terms of additional information they may need or would like to help us come to an informed decision and feel secure in the decision that we have made? Is there anything you consider we could do or information we could seek? Anybody have any thoughts on that?
I think that's difficult, Chair. If you ask various parties or protagonists to the issue, they're just going to come and give you why they think it will increase or not increase as insurance. And that's not what this business is about. I think we have to, at the end of the day, I think it's sensible that we invite the Government Actuary to make a presentation in respect of this. Hopefully we will have an understanding of what they're saying. I know from dealing with them as a pension trustee that they make a lot of effort to try and explain some very complex issues, and they will do that. Certainly the individual I met previously did that. But we can only but hope that they will provide a reasonable and fair explanation. I don't know whether they will stray into the area of the surrounding effects of insurance costs. My suspicion is they won't. But I think we probably have to, for the completeness of this committee, I think it's absolutely right that GAD should come and that we should give them a hearing to try further to understand the situation. But I think at that stage we have to make a decision.
That's right, Stuart. I know that has been your position. I suppose what I'm trying to do is, last time members, there were a number of members who had issues with this, and who wanted to better understand not just the implications but how the process worked, and so on. And the department has striven to try and get us that information, but the more they got us, the more confused sometimes things became in terms of what we were being asked to do. So to try and get us back and focus on the decision and the things that we may need to make that decision, is there anything else that members would like, or are you content that once you hear from the Government Actuaries Department, that may be all you need? Ciara, have your hand up.
Obviously, I had raised a number of issues, particularly in the relation to the 47 years versus the 30 years, and trying to understand that, and obviously options in that, and a couple of other areas. So I think I would be keen just to finally hear from the actuary themselves, so we can clearly kind of get a full picture and understanding. Because I'm just conscious, even the last committee had mentioned regarding doing like an impact assessment, and in the report, the response that we received, they basically says there's no need for one, which I think probably is new to the previous members and ourselves. So it will be really, really good. Just I think there's a couple of still kind of grey areas, and it's just about having more understanding and then obviously proceeding with a decision.
I think that's the issue, but I live in more in hope than expectation that God will get us to that point. That's why I just wanted to put it out to members if there's anything else they thought that might be helpful, but that's fine. We'll move ahead with God. If anything else occurs, then please raise it, and we'll see what we can do to facilitate that, to make sure that everybody is content, or sufficiently content to feel like they can progress to making a decision one way or another. Thank you very much, members. The other issue under matters arising is 4.2, which is the Ministry of Justice proposed amendment to GDPR. The Department has written to the committee regarding an amendment to the General Data Protection Regulation that the Ministry of Justice intends to table on the 29th of May 2024. GDPR is a non-devolved issue, so the government will not require a legislative consent motion, and the correspondence was for information only, and Caroline sent it to me this morning. This is going to be included in your pack for next week. It'll be issued on Tuesday, but given that this is going through the House of Commons either on Friday, Monday or Tuesday, we felt it was better to notify you anyway. So the letter doesn't have massive amounts of detail, and it's not urgent for us. All we're asked to do is note it. But timing was a problem. So it's just to advise you that will be included in next week's pack. Does anybody have any questions they want to ask on that? No, everybody's fine. Thank you. Agenda item 5 then is enabling access enabling access to justice programme. So I'd refer members to pages 32 to 55 of your meeting pack for the relevant papers. Departmental officials are in attendance to provide an update on the work of the Enabling Access to Justice programme, and I would welcome to the meeting and invite them to come forward Stephen Allison, who is the Deputy Director of the Enabling Access to Justice Division, Brona O'Reilly, who's the Head of the Modernisation Programme, John Bradley, who's the Head of Civil Legal Aid Reform, and Chris Barry, who's the Head of Taxation Review. Everybody, you're very welcome to the meeting. Thank you for bearing with us while we work through some housekeeping issues there. I'm now going to hand over to you to give us your presentation. We've received your papers, thank you. And at the end, no doubt we'll have some questions for you. Thank you very much.
Thank you very much, Chair, and thank you and the committee for the opportunity to speak to you today. I'm conscious and hopeful that we'll be engaging with the committee at various points over coming months at various milestones in relation to the reform programme. But we thought it would be helpful today to maybe set out the context of that programme. Chair, you've already taken a little bit of my speech in terms of doing the introductions, so I'll not take the time. I'm conscious that we'll want to get to questions and discussion as quickly as possible. As you'll know, the division is responsible for ensuring appropriate options and supports are in place to ensure citizens have access to justice, particularly the most vulnerable in our society. That includes setting the strategic framework for legal aid, including who's eligible for legal aid, what is available in legal aid, and the appropriate levels and fair remuneration for solicitors and barristers who deliver that service on behalf of citizens. We also enable the work of other departments and business areas by just looking and supporting them, assessing the impact of legal aid in terms of some of their work streams. So, for example, the work that the Executive Office has taken forward in relation to the Truth and Recovery Programme, historical institutional abuse, and also the Adult Protection Bill that Department of Health colleagues are also taking forward. It's critical for the Department of Justice with our budgets and the constrained budgets that we understand the impact of any expenditure on the legal aid fund. We have a broad remit, and the scope of the work and the potential reform in this area can be significant. So we've established a 5-pillar programme covering modernisation programme, the civil and criminal legal aid frameworks, taxation reform, and the statutory registration scheme. And the programme has been designed as a mechanism to ensure cohesion and managing linkages and to enable effective prioritisation. You'll note from the brief that we've established 2 separate forums. One is a stakeholder engagement forum with partners in the justice sector, voluntary organisation, people who've got real-time life experiences of working in and experience of the justice system to help inform the development of reform options. We want to hear from those individuals and those groups to tell us, well, what do you know? What have you got that we could learn from? We've established separately an equality forum. And that equality forum is focused on identifying and understanding any hidden barriers or challenges which may prevent access to justice. So that's really 2 very important groups for us to engage with. It doesn't stop the day-to-day work that my colleagues who are here with me today and also back in the division, engaging on a day and daily basis with practitioners, voluntary organisations, anyone involved who has experience or wants to have a view on this, we want to listen to. We're also exploring opportunities to enhance our policy development through collaboration, just to avail of the skills and experiences of other partner organisations. One example, the Commissioner Designate for the Victims of Crime is undertaking work to help identify potential barriers to victims of domestic abuse, including the legal aid waiver. And we want to work alongside Jerry on that and engage in that research and use that research to inform our policy. So if there's information out there, we want to try and reach out as far as possible to understand what evidence is there to inform the development of policy options that will ultimately be placed before the Minister to make a determination. I'll touch on briefly, Chair, in the pack we give you a comparator of other jurisdictions in terms of high level. We want to learn from other jurisdictions, so I will put the health warning. I think we put it in the pack. It's still subject to statistical verification, those metrics, but they are pretty stark. And we need to understand what our differences are. Why is ours so high compared to other jurisdictions? What can we learn from other jurisdictions? What do we retain in our jurisdiction? So we're very much at the early stage. And I think that's probably the thing today, Chair, that we recognise we're at a very early stage in gathering the evidence across most of the work streams. We're a bit further on with Judge Burgess in his criminal legal aid review. It's coming to fruition at the end of next month. But we're at a very early stage to gather the evidence to inform the development of reform options. And we're keen to listen to citizens, practitioners, and anyone who's got experience in that space. It'll be important for us as well, the commitment we have, Chair, is we want to engage with yourselves and the Access to Justice all-party working group as we go through each of the milestones, so we can keep you informed, updated, and also to hear from you about our proposals and our approach, so we can also take that on board into our consideration. But I promised I'd keep things brief, so that's, I think, an appropriate point for me to stop and allow the committee to ask questions.
Members, does anybody have anything? I'm gonna. I'll start. I usually go at the end, but I'll start on this occasion. Can I ask? So there's reference within the papers that we have to the taxing master and the proposal that these issues would move to the accounting officer, who presumably is the permanent secretary within the department. Could I ask, sorry, my papers have just disappeared from the screen. Could Could I ask you to take a step back from that? Because I think that there's a presumption of knowledge that some of us don't have. Could I ask you to maybe step back, explain how the current proposal works, or how the current situation works with the taxing master, and what that setup is. And from what I read, the issue there was trying to, I suppose, take account of a PAC recommendation that said there should be a bit more accountability around this. So it would be, but the Law Society, I think it was, responded to say they didn't think it was necessary and they had some concerns around it. Could I inquire then what information PAC had with regard to making the decision? Because part of this is making sure that people who understand the legal process and the extent of the work involved are involved in the fees. So how are you going to strike that balance? Did PAC give consideration to this? And what information did they have before they made the recommendation? Because it seems to me you're moving on their recommendation, but the practitioners have some concerns.
I'll set the background and context, and first of all, Chair, I'll invite Chris, who leads on taxation, to maybe speak specifically about PAC and the origins of PAC's recommendation and where we're at. In terms of the process as it is at the moment, there's about £20 million a year expended out of the legal aid fund on the order on the certificate of the taxing master, a judicial office holder. She's a judge. It covers a number of areas, mostly in the civil and family space, in terms of the areas that go to taxation. Criminal Court of Appeal is the only area of the criminal space that goes to taxing master. And what will typically happen is the bills from solicitors, a bill of costs from the solicitor, which will include the brief fee, which is the only time brief fee appears in legal aid expenditure, will appear on the bill of costs that is presented to the taxing master. The taxing master will then consider the bill of costs. It's quite from what I've seen, certainly a very detailed line-by-line expenditure from the solicitors, and then maybe one line saying what the brief fee is for the barrister. The taxing master's role is to look at that bill of costs and to assess whether it's appropriate, and then reach an order. I think, Chris will keep me right here if I've got the figures wrong. In 2017, when the PAC looked at this area, on average, the taxing master is reducing the cost of the bills being presented by about 13% across the board. Now, that was the average. Clearly, there'd be outriders either side of that. In terms of the accounting side of things and the transparency, the difficulty for the department, which was recognised by PAC, is our role simply at that point is when LSA, Legal Services Agency, receive the certificate from the taxing master, we simply have to pay. We have got no skin in the game to say, is that appropriate? We've got no fee structure to look to say, what's the basis of that? So in terms of predictability of budget, transparency of how the bill of costs was put together, what was the basis of that, what was the basis of the assessment by the taxing master, none of that's within the purview of the accounting officer and the officials in the department or LSA. And £20 million, about a fifth of the annual expenditure, is ordered without any oversight from the department. Now, that is not any criticism of the taxing master. We have to make that very clear. Taxing master has an independent role. But unlike all other elements of the legal aid fund, we can speak to all other elements of the legal fund. Rightly or wrongly, there are set in standardised fees or a fee structure going back, in some cases, years, lots of years. But at least there is a schedule of fees that people can say, well, that's what you get for that piece of work. Yep. We don't have that in the taxing master, in the taxation space.
That's actually really helpful, because the brief fee is an issue that I raised with the bar whenever they were in front of us, and I asked them to give us some understanding of what it was and how it was calculated, and I asked them to come back to us in writing on that. We haven't received their responses yet, but yes, as you say, it's very difficult to probe that when you have no understanding as to what's behind it and the level of work involved. in a way that isn't the case with solicitors.
We've, I mean, being entirely candid, Chair, my understanding of how a brief fee is it's made up is born out of the last 10 years of receiving a brief fee when I'm paying for barristers representing the department in JRs. That's as limited as. So we've asked the same question of the bar, help us understand the component parts. Now, we're also waiting for details on that. If you refer to the bar, they are going to engage with us. Chris, would you want to add anything in terms of the current process that we have?
I mean, I think you've covered it really well there, Stephen. We, as you mentioned, Chair, we've also asked the bar about the brief fee. I mean, we have a basic understanding in that it covers preparatory work and up to the first day of trial. How it's calculated is the question, I suppose, because what we're seeing it is a line on the solicitor's bill of costs. We're trying to get more information on that. We understand that more information is provided to the taxing master for the purposes of her assessment, and we're engaging with the taxing master's office to try and get some more information that she might receive, so that we can we're trying to get as full an understanding as we can from any source that we can. We have asked the bar and are awaiting a response. I understand you're awaiting a response to the same question. And we're also liaising with cost drawers, who primarily will work to solicitors in terms of drawing up the bill of costs. But again, we're asking for their, based on their experience and their knowledge, their specialist knowledge, what information might they have in relation to the brief fee. So we are trying to cover all aspects of that and get to the bottom of what it might be for the purposes of what does it represent now and what might we then utilise from it, or what might we change then if we are going to design something that will come under the purview of the accounting officer and give us greater accountability and transparency.
Sure, there's just building on Chris's point, there's two areas we've identified as yourselves. The brief fee, completely, we just need to understand how that's made up. When I bring it back to, if I'm employing a builder will give me a bill of cost, and I'll understand what I'm paying for or what I'm not paying for. I don't have that same understanding on a brief fee. The other element that we've identified at current landscaping stage is the uplift that solicitors apply to their hourly rate across the bill of costs. And we're getting a bit of consistency in terms of our analysis. So I'll invite Chris to give you some of the more detailed figures. But the current rate, the hourly rate struck by the judiciary in 2014 for solicitors is £102 per hour. Now that was the 2014 rate. What we're seeing in most of our sample is solicitors will apply an uplift to that hourly rate depending on the complexity of the case. Now there is case law supporting the rationale for doing that, so that's fine. It's just the level of uplift is, there's certain consistency, but I'll get Chris to give you the figures here in a second. It can be fairly subjective. We're looking at it going, at some points it can be 33%, at sometimes it goes up to 200% uplift on top of the £102, so you get a £300 hourly rate. And that's not across the board consistent. So you can see, Chair, hopefully that when we're looking at taxation, it's about bringing consistency, about bringing a transparency to the process, that everybody knows, well, that's what you get for that there particular transaction, that's what we will pay, that's what we can predict in the next year's budget, that we can then make it, a case for.
Does this include criminal legal aid?
Criminal legal aid doesn't come into that space,
This
only
is all
in
just
criminal
family
court
and
of
civil.
appeal.
Okay.
The only part that comes into taxation on the criminal space is criminal court of appeal cases. It's not currently got, so we need to look at that at a future point. We're not taking that on at the moment. It's just a little bit too complex. We want to get our methodology. I want to dip our toe in this one, to be fair, Chair. It's described to me recently as something like out of Hogwarts Castle dealing with taxation. It is mystifying at times. We're trying to understand exactly the component parts. Chris, do you want to, in terms of the hourly rate, because I think the hourly rate gives you £102 an hour, and then that's not the standard. There is an uplift.
Yeah,
Sorry,
Stephen. As Stephen mentioned, we've been reviewing a small sample of bills right across the various proceeding types that you'll find in the High Court. There's the £102 an hour, which the bill, I suppose, is your starting point for assessing a solicitor's bill. And what we're finding is that there are consistencies. So to break it down as quickly as I can, for consultations at court, solicitors will apply a 33.3% uplift to the hourly rate. For hearings at court, they'll apply a 50% uplift. And then for preparation work, so reading, consultations and stuff like that, they'll also apply a 50% uplift. And what we're finding is that preparation element is where you'll see variations in the uplift being requested. I suppose these are your standards. We have not come across a bill that has no uplift. I don't know where they're written down, if they are written down, but this is consistent across the board. The preparation one is where you'll see, in which Stephen alluded to, the higher uplifts. So for a JR, for example, children order, complex cases of children order, your standard is 65% there, rising above that. And that's if the solicitor's on the children order panel. It will go above that if they feel that there's complexities. The uplift, we're calling it an uplift. It's for current conduct. That's how it's defined, and you'll find it in the rules of the Court of Judicature as how the Master assesses it. It's for current conduct of the case. It has a basis in case law, and as I say, it is in every bill that we see.
Just to circle back to the Tax Master, Chair, the 2017 13% average, we're not seeing that sort of deviating too much from that in our current small sample size. So the PAC recognised that the Tax Master's role in terms of 13% reduction on the bills was helpful, contributing to managing public money. But because it's completely out with the department, our sole role is to pay the bill. We have got no input into the fees, establishing the fees, saying what citizens are getting for that hour. We're not involved in that space, and that's why the previous Perm Secretary took the decision in April, agreed that we should move to accept the recommendation and then move to bring all of that £20 million over the next number of years onto the purview of the Accounting Office of the DOJ, so we can actually standardise the fee structure as much as possible, get greater transparency in the setting the bills, and we need to work through obviously the implications for LSA colleagues in terms of assessing those bills rather than the assessment process that the Tax Master has. So there will be a resource implication for LSA.
Ultimately it's a significant amount of public money, so there needs to be probity and transparency, I think.
That's exactly where the Perm Sec landed, and that is it's a fifth of our spend on legal aid. And
presumably then the PAC took all of this into account when they made their recommendation.
Very much so. They did an exhaustive exercise in this. Certainly, I think the recommendation is based on just bringing it into transparency. There was no commentary in terms of the Tax Master's role, other than it's outside the department with no skins. But yes, the short answer is PAC took this into consideration.
Thank you. I see that I've got members waiting, and I'll not prolong it. But I just had one other question, which is with regard to the table at the end that you've provided us with. Can I just check with officials, because I had to restart my machine. I'm not clear what page it's on. 42. What page? 42. Thank you. Sorry, I had the panic where my entire machine shut down and I had to restart. I'm really interested in the disparity of Northern Ireland figures versus the other places that you've cited. And I suppose my areas of interest are, one, whether or not the legal systems in these places are the same as ours and have the same kind of throughput, the same process. Yeah. Secondly, I'm not clear how ours are so different when what we have heard is, and we've heard it from the profession, but we've also heard from the victims sector, that the fee structure hasn't been reviewed, I think, literally for decades. So the fees are from a long time ago. And more than that, the thresholds to receive legal aid are out of step now with people's income, which means that many people who should get legal aid are not getting legal aid because the thresholds just don't tie in. So you've got fees that haven't increased, people who can't get it because the thresholds haven't changed in accordance with inflation. And also it's quite, as I understand, it's quite an invasive process to qualify for legal aid. So, everything, your whole financial circumstances looked at, including whether or not you even have an account with a betting office, and any kind of gambling, account. So all of these things are looked at. So everybody who's getting it qualifies. There are many who should, who don't. The fees haven't changed, and yet why are we so out of kilter? I presume that's what you're trying to understand, but it would be helpful to have some degree of information with regard to your findings thus far.
I think, Chair, you've touched on some of the variables that we haven't got to help us understand, so that we're struggling to understand that for the same reasons you've outlined. I think, taking your first observation, we have to place the caveat that it isn't like for like in terms of legal systems and scope. So the first variable that we need to understand is what proportion of our population that's eligible for legal aid is actually going through cases compared to the eligible. Because I look at the civil space, Scotland's got 70% eligibility, 70% of their population is eligible for legal aid in terms of scope and eligibility thresholds, and yet they're significantly lower in terms of cost per head. So is the variable there's less people going through the system in Scotland compared to Northern Ireland? We don't know. It could simply be that. It could be our scope, certainly. I mean, I've heard from barristers in Dublin a couple of weeks ago, speaking to a couple who are saying, they're international barristers, saying your jurisdiction is the envy of the globe in terms of scope. I mean, you literally can walk off the street into any high street solicitor and get advice and assistance. That's not what you get in other jurisdictions. So we are really struggling to understand the stark difference here as much as yourself, Chair. I'm being really candid here. We really need to understand, well, is it the throughput of numbers? Is it the combination of throughput of numbers, differences in system? Is it that there are other organisations, other jurisdictions are actually spending more on alternative mechanisms, not legal aid, that citizens are getting access to justice without having to go into a court? Because that's something, and certainly Brona and myself would be very passionate about in terms of the modernisation programme. Not every citizen gets an outcome through a court that will help them in terms of the outcome or also their well-being. There's other ways of actually getting a form of justice. So access to justice isn't always in a courtroom. So I'm sorry, I'm not able to give you an answer, Chair, because to be honest, we presented this to you to say, look, this is where we're at, and this is our starting point. I need to understand, my team and I need to understand, why are these differences there? What are we doing really well that we get value for money on? Where can we redivert money to? It's certainly not about reducing the £67 a head. What I'd like to do is maximise every pound that's available to the Department of Justice on legal aid to give citizens the best access to justice. It's not about looking at that figure to say, how can we move it down? You need to take the spend down by about 48 million to get it near England and Wales. That's just not going to happen.
Yeah, no, Steve, we don't expect you to have all the answers at this stage, and I think it's a really interesting area, and I think at times it is sensationalised, which isn't helpful either, because people need this and they need to be able to access justice. So it'll be really helpful, and I suppose we'll be really interested in your journey as to the information that you find out along this. I'm going to open the floor to other members. I've got Justin and then Stuart. Thank you very much.
Sure.
Justin?
On mute. Mute.
Justin, you're on mute, I think.
We're doubling up there. Forgive me, Chair. Thanks, Chair. Thanks, folks, for your evidence thus far. Regarding the fundamental review of civil legal services running from the 22nd of April until the 18th of June, the early response has been encouraging, with 15 responses received to date. Would this be a standard amount of responses, and do you know how many people would have been eligible for the survey to respond to it? And can we really make recommendations for reform and use public money to do so based on 15 responses?
I think when we give those figures, it was within the first fortnight of the call for evidence. They've increased in terms of the responses to the questionnaire, but we've made clear to everyone that we've contacted in the call for evidence, the questionnaire is one vehicle to provide us with your views. It's a structured questionnaire online. Complementing that, we've also said, we've already had individuals in society commentators saying, we'll take you up on the offer of meeting with you or having a telephone conversation. So we've also had that. We also have planned meetings with a number of stakeholders. So, for example, Women's Aid are doing a very substantive submission. It hasn't come through yet, and I'm meeting with Women's Aid, I think, on the 13th of June to go through some of that. So you're quite right. If we only had 15, it would be a small evidence base, but it's early days when we give the 15. That number's increased in terms of questionnaires. Typically, what I understand when we went through this, we were surprised the 15 came in so quick. So normally when questionnaires you get the tsunami of responses near the end, when you're reminding people about the deadline, and I anticipate that'll still happen. So what we have is, in terms of the eligible populations, anyone who wants to go on to the call for evidence questionnaire for civil society, any practitioner on the legal questionnaire, we're encouraging anyone to fill that in. I'd encourage you to encourage anyone to fill that in. So what we're trying to do is just trying to encourage the conversation, to give people the chance to give us their views, either in the questionnaire, in separate submissions, in telephone conversations or face-to-face or online meetings. We've extended the period, not for the questionnaires to be submitted, but we've allowed another 4 weeks to facilitate face-to-face meetings, online meetings, and any further discussions anybody wants to have with us. So we're not denying anybody the chance to have a conversation with us, to give us their view. So hopefully that's covered some of your questions.
Okay, well, one more question. Are there currently appropriate levels of legal representation, and is there any evidence of legal representatives not taking on legal aid work because of the department's policy in relation to payment delays?
Hard one to answer that, insofar as we haven't had anyone saying to us directly. Anecdotally, we're hearing that from various sources, but not widespread. I think some of the responses that we've started to see coming through from the legal profession are saying it's becoming increasingly difficult for them to take on the work because they're not seeing the value for their company, for their bottom line. And again, that's really important. We've asked specific questions around that to actually understand what's happening here in terms of the remuneration levels. Does that have an impact on the viability of the legal profession? It's an area separately that Judge Burgess is also going to be reporting on at the end of June in terms of his findings about the viability of the profession. Are the remuneration levels actually driving people away from providing legal aid? Because clearly we need service providers to provide that support to citizens.
Well, this is more than remuneration levels. This is about the policy of payment delay.
Well, I mean, there isn't a policy on payment delay. I mean, as such, there is a LSA. Paul Andrews has spoken to this, I think, in the past. There is a cash budget that has to be managed in terms of he can't pay more than he's already got in the bank, so to speak. So, but I have no evidence to be clear that is driving people away from the profession or providing legal aid.
Maybe just to build on what Stephen said about that, one of the things that we want to try to understand is whether any aspect of the legal aid system as it currently stands is acting as a barrier to people providing services, coming into the services, or is motivating people to move away from the provision of legal aid. So one aspect of the internal data analysis part of our work is we're going to look at the number of certificates granted, the number of firms to whom legal aid certificates have been granted over the last number of years, and the geographical distribution, importantly, of the locations of those firms doing the work, so that we can see over time whether there's a change in the number of firms actively involving themselves in doing that work. The benefit of the call for evidence is it'll let us look at that trend over time and ask the question directly to legal aid suppliers and other solicitors firms. What are the barriers? What are the obstacles? What are the reasons for the patterns that we start to see in the data? So the call for evidence, one strand, it's intended to be there to give us the qualitative information, to do some of the hows and the whys, to explain what we're seeing in terms of the data, in terms of the pure numbers. So
Can I just come in on that
yes,
point?
of course.
So you're going to try to ascertain the number of firms that have certificates.
Yes.
However, that may not be reflective of the position, because the number of firms may remain the same, but a number of those firms will have had to contract because they can't afford to employ additional solicitors.
Yes.
Moreover, I think in terms of people coming into the profession, they're not what we're hearing is they're not moving into the legal aid space, they're going to corporate because that's where the money is.
Yeah.
And that's where the career paths are, because people who are engaged in legal aid, their practice is currently under threat. So you may not see anything with regard to the number of firms who have certificates,
Yeah.
but the key is going to be the number of solicitors who are practicing legal aid work.
Of course, what we'll have visibility on is the number of certificates granted and the number of and the firms to whom those are granted. So we're able to see volumes of work, legal aid work done by firms in different places. You're quite right. We won't see numbers of solicitors employed, which is why we need to build on the data part, the internal legal aid data part of our research agenda by going directly to firms involved and asking them to tell us about their experience of operating the legal aid system and the barriers that it throws up. We're hopeful that volumes of certificates and volumes of payments to firms in different locations will tell us something about the extent of coverage, the extent of supply, and the extent to which firms are doing less legal aid work than they used to or withdrawing from it entirely. But the call for evidence will be absolutely crucial in telling us what that data actually means about the motivations behind the firm's behaviour.
I think the other thing I would say is one of the benefits, I think, of our programme in terms of bringing the 5 pillars in together and disparate projects. Judge Burgess is really examining the viability of the profession. That's what you're raising today has been raised with Tom throughout the last 7 to 8 months. And Tom has secured through the Law Society agreement to get behind the books of some of the solicitors' firms to actually understand exactly your point, Chair. How many people were actually working on legal aid in that firm 5 years ago? How many is now working in that legal aid firm? Why they're not working in that? And Tom's report on the criminal space, and there's nothing to suggest the criminal space is going to be any different in terms of the reasons and the rationale than we will have in the civil, will certainly reflect reasons and experiences of solicitors' firms specifically saying they are downsizing, or they're not recruiting criminal, or they can't recruit criminal, or it's not profitable to recruit criminal. We need to do something similar at a later point on the civil space. Now, I know the committee had asked for rationale why we weren't doing the same approach with civil as we were on criminal in terms of an independent review. And I think a letter issued last night to Committee Clerk. But just to explain that, at this point in time, the call for evidence is to try and help us understand the current landscape. What are the general themes so that we can start doing high-level impact assessments, to provide the Minister with potential reform opportunities by the end of September, and for the Minister then to make a decision on the breadth and depth of how far she wants us to go into. That in itself will then inform our methodology. So once we understand, well, how big a bite are we taking of reform here, that might take us into the independent space, and that might afford confidence from some of the solicitors' firms in the civil and family space to do what the criminal firms are doing with Tom, opening up their books and having a conversation about the viability of their particular industry. We'll not get it. I mean, if I ask firms to show me their books, I can understand they're going to say no. But it's something that, in stark terms, I mean, we need people to help us deliver services in court. We need solicitors and barristers. We're lucky in this jurisdiction we have excellent quality service from solicitors and barristers. We just have to find a way of making sure that people are attracted into that space and that we contribute to that attraction. We can't pull all the levers. I don't think it's the Department of Justice can say we're going to end up finding a solution to entice young people into criminal law and keep them there. But we can contribute to that discussion and that solution.
Actually, another point that we kind of have discovered is this issue about apprenticeships, because the smaller firms are kind of being precluded from taking apprentices because they can't afford to pay them over this 2 years. So that again may have an impact. We've sought information that's in our pack today from the Institute to establish, is the Institute seeing an impact as a result of this? They're saying it's too early to tell. But again, this is another factor with getting people into the profession, getting them into the legal aid part of the profession, because it's going to have a massive impact on access to justice. So that may be something that you look at too in accordance with your
We have
inquiry.
On the criminal space, Tom spent quite a bit of time with the Institute in Queen's, and some of the metrics coming out of his findings in that are stark. You know, at the moment, one individual saying out of 100 in her class in the Institute, in her year in the Institute, 3 are in criminal law contracts. That's what we have. So there is, clear evidence at the early stage of bringing people in. But we also have Queen's telling us that, you know, the most popular module, compulsory module, is criminal law. First year, it's the most popular, most well attended. People are attracted to that. But they also say that more often not outside Queen's, you'll have the commercials pitching a tent saying, here's a placement, here's awards, here's prizes. So we're competing in that space, and it's difficult to see how we can compete on an equal footing on that. But the metrics are stark on the criminal space. We recognise that.
Justin, have you finished, or do you have anything else?
Finished, Chair. Just it's interesting to note in relation to access to justice that we're asking questions about payment delays and denying access to justice. So, thank you, folks.
Thanks, Justin Stewart.
Yeah, Chair. Again, just partly just to say that the audit report obviously highlights the urgent need to address the issue of openness and transparency. This is public money at the end of the day, and it's been obscured for too long. Let's be honest about that. Who pays the taxing master? Who's his employer or their employer?
Well, the master's a master of the High Court. She's a High Court judge and responsible to the Lady Chief Justice.
So was that funded by DOJ then?
Good question.
Good question.
The taxing function is funded by a stamp duty that's paid by the people submitting bills for taxation. So the process, when a bill is submitted for taxation by the representative, for legal aid purposes, they pay a fee to the taxing office, which acts as court service revenue, and that's then repaid to the representative through their legal aid certificate. So it's a payment essentially out of the legal aid fund to the representative to pay the fee for the taxing master. As things happen,
The master is also the head of the Enforcement of Judgments Office, so she has other responsibilities within. But she is a member of a salaried member of the judiciary. John's absolutely right. There's the stamp duty element, which is towards the costs of the taxation, if you like. It's a percentage of the amount that is assessed that has to be paid by the solicitor.
And I suppose that begs the question then, is that the right place for this role to sit? Is it right for it to sit in the independent judiciary? Or, as this is public money, should it not be, as potentially the proposal here is, that it should sit under the purview of the Permanent Secretary as an accounting officer for public money?
That's the whole, one of the key objectives of our taxation reform is to move the assessment process away from the judicial office holder into more likely the legal services agency in the same role as they assess any other bill coming in on taxation, on legal aid. They'll have the same responsibility. So the taxing master will have no role in ordering certificates or order payments through the legal aid fund as we go through this. So we are removing that responsibility on the legal aid spend. Tax master still has a role in taxation of other non-legal aid cases. Sure. And that's fine. That'll remain.
The industry, as it were.
Yeah, exactly.
And if that's how they want their business dealt with, that's up to them. I suppose one might argue that ultimately, when the move is made, or if the move is made and the arguments are made for that it might have an impact on those other aspects of what they do, but that's up to them, presumably.
There could be potential repercussions there, but I mean, our focus is, as you have identified, it's bringing that openness and transparency and predictability into the department, under the purview of the department, so that we can understand what the bills are, what we're being asked to pay for.
Just one other thing, in relation to what happens in other jurisdictions in Scotland and England and Wales, is there a similar taxing master role, or is that already moved on, or did it ever exist?
And then pass this on to Chris, because
I can
Chris
take
can
this
speak.
one. We've spoken to colleagues in England and Wales. They've kind of went through this process already. There is cost judges in England and Wales, and costs officers who are court staff. At the minute, practitioners can elect to have their bill assessed by a costs judge or officer, or they can seek assessment by the legal aid agency. When we met with colleagues there, their latest data on the breakdown of that was 95% are electing to go for assessment via the legal aid agency. So it's all but come under the purview of the accounting officer there, if you like. In Scotland, it's a different legal system, and it's known as the auditor. The Scottish Legal Aid Board will assess bills in the higher courts, and the auditor's role is really a appellate role, where there's a breakdown or a dispute over what should be paid. In the Republic, we are hoping to engage with colleagues in the near future with regards to this. Again, different legal system, but broadly comparable in that judges will order costs for payment, and that bill will then fall to the Ministry of Justice. They do have some standard fees in legislation with regards to this work. But as I say, we're in the process of engaging with colleagues there to try and find out more and see where we can pick up lessons learned in terms of their journeys on this.
Will all of this be an opportunity to standardise more fees or to look at the whole fee structure as well?
We'll have to, because at the moment we don't have a basis for the fees. I mean,
Not exactly.
we will need to establish. So we've recently, last month, we've taken a decision that we're going to look at High Court bail as the first area under taxation. So High Court bail represents about 25% of the volume of cases that the taxing master will look at. It's only about 3% of the quantum, but it's
a discrete area.
It's a discrete area, and we can test our methodology, get confidence in how we're doing that.
Yes.
But we already have a standard fee for High Court bail, but a lot of the legal profession, well, not a lot, the 25% of cases when the legal profession say they're not taking that £180 for the High Court bail application, and they opt for taxation, so they can go both routes. We will look at that and see, well, is £180 viable, the proper rate? If we need to increase that to reflect value for money and a proper payment and fair payment for the work being done, we can increase that, but that will be an underpinned figure. It'll be a standard fee.
And ultimately, in terms of reviewing fees, then, in order to provide equity for those who receive the money, will you be looking at some form of independent assessment of the value of a fee for a particular task?
One of the things, again, go back, it seems like I'm going back to Judge Burgess quite a bit here, but one of Tom's terms of reference was to look at the mechanism for reviewing, because currently on the civil and family and criminal legal aid space, there are statutory obligations on the department to review the remuneration levels at various intervals, and candidly, I think they're not being met in the timeframes that we'd like, because we get run into sand in terms of engagement data sets that need to be developed. We're looking for Tom in the first instance to say, well, what are your recommendations to break that cycle and to actually have a model that doesn't hoover up resources just to look at fees every 2-3 years, but we can look at that on the continuum. We're doing it all the time, and new offences are created, we have to create a new fee.
Well, that was my next question. How do you assess a fee for a new offence?
We will go through legal aid impact assessment. So if someone brings in, for example, stalking crime or hate crime legislation in a new offence, my team will sit and go through the legal aid impact assessment and go, okay, where's that comparable in the fee structure? So we looked at for like at the moment. If we have to create a new line in the statute, we put that through the Assembly and have that in statute. But we're using the benchmark of the figures we have at the moment. I'd like to get it to a point where we're broadening it out, that it's not the DOJ having to be, completely knowledgeable on all of this, area, dependent on data sets, that we bring in independent subject expertise to help inform on an advisory basis, at the very least. And that may flow from both the civil legal aid review and the criminal legal aid review, that we might get that point in some time in the future.
That's been very helpful. Thank you very much. Thank you, Chair.
Okay, Ciara? Ciara, you're on mute, I think.
Apologies for that. I was looking at the paper between, just in relation to your paper, all is quite detailed and there's a lot of extensive work happening. And maybe it's not for now, but it would be useful just in relation to the current delivery plan. Obviously, over this past year or two, that you've listed a number of kind of key areas of ongoing work. The likes of the private family law early resolution action plan, the pilot of a general authority for legal aid for intra-court mediation stuff. It would be useful maybe just to see further detailed information on them and the impact that they're currently having. But I'm assuming, I'm not expecting you to do it today, but even if we could get a written report, thank you.
More than happy to provide an update on those. Those are certainly, as Brona has said earlier, we're particularly passionate on the modernisation space, because I think we can do an awful lot there for citizens without necessarily asking them to go through a court process. They'll be very ably supported by solicitors and barristers and the court processes themselves, but it's not always the right option for everyone. So the more we can do in that space, the more we're enabling access to justice. But more than happy to provide, we'll definitely provide an update. I'm happy to do that.
That's great. Thank you.
Thank you. Before you leave, folks, there's just one other issue. In our papers, there's mention of that you're currently supporting the Department of Health Adult Protection Bill team to ensure the impact the Legal Aid Fund is fully included in their business case and funds provided accordingly. It's a complex bill with 5 new criminal summary or indictable offences and a number of civil orders being created, and has therefore significant resource implications for the Legal Aid Fund and the division. So I think it's important that that's on our radar. And I suppose what I'm asking you is, you know, when is the bill going to be laid, and how will we be kept informed about the implications of that beyond the Assembly Chamber?
I'm going, because John's been leading on this, definitely deferring to John's expertise here, Chair.
Yeah, I'm not sure of the Department of Health's planned date for the introduction of the bill, to be frank. But we can go and
come
seek
back
a
to
response to you on that.
We can check that out with the Department of Health,
Well,
I think, can't we? Could we?
It would be nice to have an update. I think the date has changed a number of times over time, as usual in these sort of circumstances. I mean, when it comes to the legal aid implications and the changes, if any, to the legal aid system that will be required in response to the DOH provisions, when we come to introduce those, we'll brief the committee in the usual way. So any legislative changes to legal aid that are required will be subject to public consultation, the usual impact assessment processes and economic appraisals, and we'll bring the findings of those to the committee as they come forward.
If it helps, Chair, I mean, it wouldn't be too difficult for us, you know, on a regular basis to provide you with these are the areas that we're currently doing impact assessments on across the piece, because with DOHS, but also agriculture will come up with environmental offences and so forth that we haven't got that at the moment. But so if it's helpful to the committee, we can on a regular basis just give you an update. Here's the current table of impact assessments that we're working on and from what areas.
I don't know whether members want that, whether it's kind of additional information, some of which we wouldn't necessarily require. It's just on the case of this, where there could be a significant impact on the legal aid budget, then I think it would be important that that would be somewhere on our radar. You know, so maybe if we're looking at significant impact, it might be helpful to have that brought to our attention.
Not on it because it's.
And then the next thing is define significant, but you know what we're saying.
Yeah, yeah.
Thank you. So, is everybody happy that they've had their opportunity to ask anything they needed? No? Then that's great. Thank you very much.
Thank you.
I really appreciate that briefing. Thank you. It was really interesting and helpful. Members, agenda item 6 is the LCM on the Post Office Horizon System Offences Bill. Thank you very much, everybody. And the draft committee report. So could I ask you to turn to pages 57 to 70 of your packs, please? We're just going to work our way through this. You'll know that at last week's meeting the committee agreed that it was content with the Department of Justice's proposal to extend the provisions in this bill to Northern Ireland by way of an LCM. Originally, prior to yesterday I think, we were going to work on the basis that typos and formatting errors and so on would be fixed, and we would get the report back next week. However, now that the general election has been called, I think the team is eager that we would agree the report today, so that it could be all ready and published for MLAs and on our webpage. So, do members have any proposed amendments to the draft report as things stand? Or do you want to raise them as we work our way through? Just work our way through? Right. All right. So, the title page, contents page, and committee membership and powers page. So, I would refer you all to, first of all, the title page, contents page, and powers and membership page. Are you content that those would stand part of the report?
Agreed.
Thank you. Then if I could ask you to turn to the background, which is at page 61 of your pack, and it's going to be paragraphs 1 to 7. Does anybody have any amendments to these, or are you content that they stand part of the report?
Okay.
Content? Thank you. The purpose of the LCM, which is at paragraph 8 of the report, which outlines the purpose of the legislative consent motion. Are you content?
Yes.
Thank you. Any consideration of the LCM, which is at paragraphs 9 to 17 of the report.
Fine.
You're content that it stands part, yes? Thank you. And then the conclusion, which is at paragraphs 18 and 19 of the report. Any amendments to that? I think I would maybe like something in there about around the political agreement. I think this was reasonably hard won, and I think that we should perhaps make reference to the so it mentions political agreement. I think we should also talk about political collaboration that there was between the Minister for Justice, the First and Deputy First Ministers, and the unanimity of the Assembly. I think that it would give some public confidence.
Yeah.
Would members be content with that? Thank you. So with that amendment, are members content that the conclusion stands part?
I think, sorry, there's also that we need to probably acknowledge, was there not a stage when the UK government were not willing to extend this?
Yes.
So we need to include that as cooperation as well, because they came around to...
Yes. That's kind of my point, that, you know,
Yeah.
the entirety of
In
the political
entirety
spectrum
of the-
came
of the-
together
yes,
for
yes,
this win.
we did, that's right, yeah, okay.
And that's what I was trying to, I suppose,
Mhm.
to reference within the conclusion there.
Okay.
So are members content that that's stand part? So I would refer you then to page 69 of your meeting pack, which lists items for inclusion in appendices 1 to 3 of the report. Are members content that the appendices stand part of the report?
Yep.
And can I ask for your agreement that the minutes of today's meeting be added to Appendix 2 when agreed? No, I'm going to be able to have we time to do that now?
It will just be when they're agreed at their next meeting. We can add them in retrospectively, Chair.
Right, that's great. Thank you, Caroline. Can I then ask for your agreement that the report be published on the committee's webpage and indeed issued to all MLAs? Are members agreed?
Agreed.
Thank you. Committee staff will notify members when a debate on the LCM has been scheduled, and then we'll take it from there. But thank you very much, everybody, for your work on that. Agenda item 7 is an SL1, which is proposed amendments to the Magistrates Court rules and Crown Court rules, and those are at pages 72 to 78 of your pack. The Department of Justice proposes to make a statutory rule to amend Magistrates Court rules and Crown Court rules to take into account special measures provided for in the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021, and the Protection from Stalking Act, Northern Ireland 2022. The statutory rule will be subject to the negative resolution procedure. Are members content with the proposed statutory rule, or do you have any further information or clarification you would like? Can I take it then that members are content? Thank you. Agenda item 8 is a review of the list of specified offences. So if you could turn to pages 80 to 88 of your meeting pack, please. The paper provides an update on the progress of the review of the list of specified offences. Are members content to note the paper? There's just one thing I had on this, which was, I think, in the table, there is reference to, so it's Annex A, page 88. There's reference to Scotland somewhere. Yeah, Adults with Incapacity Scotland Act. And I wondered why Scotland would be included there. Does anybody know? 88. It's the table, Annex A.
Okay.
And it's 1, 2, 3, 4, 5, 6.
Oh
The
yeah,
seventh
Adults
one
with
down.
Incapacity Scotland Act.
Anybody know? Maybe we should ask. If we can just ask around that. And then that means we can move on. Are members content that we do that?
Yeah.
Thank you. Agenda item 9 is stopping domestic and sexual violence and abuse strategy, and a progress report on year 7 and addendum to the action plan. So this is to be found at pages 90 to 111 of our meeting packs. The paper provides an update on the progress against the 7-year Stopping Domestic and Sexual Violence and Abuse Strategies current action plan. Are members content to note the briefing, or if there are any points they want to raise or questions they wish to ask? I suppose there's mention there that there's going to be a briefing to our committee and a concurrent briefing to the Health Committee prior to the publication of this at the end of June. Just for information, all right? Thank you. Agenda item 10 is the publication of the Modern Slavery and Human Trafficking Strategy 2024 to 2027. So this is at pages 113 to 115 of our meeting pack and pages 48 to 104 of the tabled pack. So essentially it's to let us know that the department has advised that it plans to publish the strategy, and we're being asked to note the intention to publish the strategy. Noted? Thank you. At some stage we may wish to consider that, but for now we'll note. Agenda item 11 is the Forward Work Programme. So an updated programme is at pages 117 to 120. Are members content to note the document, or do you wish to raise any issues? I just have one, which is whenever we are looking at the Forward Work Programme, it would be helpful. There are times when it stipulates whether something is going to be a written paper or whether it's going to be oral evidence. But in terms of some of the issues towards the top of the page with regard to primary legislation and subordinate legislation, it doesn't always indicate that. And it might be helpful for us to have an understanding as to whether or not things were going to be written, oral, and the potential time frames in as much as you can in terms of allocation of committee time. Is it feasible to ask for whether or not things are going to be written or oral?
Chairman, subordinate legislation would always be a written paper.
Okay.
I would always note if it was going to be an oral briefing on additionally, which is more the exception than the rule. Yeah, so we would tend to try to note as much as we can, but certainly we can bear that in mind going forward.
Thank you. Just to give us an understanding of kind of what the format that the meeting is going to take. Thank you. Appreciate it's not always possible, but where it could be done. Thank you. Agenda item 12 is correspondence. There's a correspondence memo and 14 items of correspondence at pages 121 to 242 of the pack. I'm going to draw your attention to 2 of the items, and then we'll have an opportunity to comment on any other items of correspondence in which any of us have a particular interest. The first one to which I'm going to draw your attention is item 7, which is correspondence from the Department of Justice regarding the legislative consent motion for the arbitration bill, and that's at pages 158 to 161 of the meeting pack. Just to advise members that given the announcement that a general election is going to be held on the 4th of July, the Department of Justice has advised that the arbitration bill will fall. Therefore, there will be no need for the committee to continue with its consideration of this LCM. In addition, you should note that we also understand the Criminal Justice Bill and the Prison Media Bill will also fall. Are members in agreement to note that?
No.
Is there anything else in terms of the correspondence that members wish to raise? No? Obviously we referenced earlier the Institute of Professional Legal Studies. That correspondence is noteworthy. They understand that yes, there is an issue. They have said that since it arose at the end of 2023, they are not yet in a position to establish the extent of the problem. So that's going to be an important one for us, I think, moving forward, to just monitor that and go back to them at some stage to establish what the figures are looking like. Are members happy enough? And obviously the Fiscal Council report there may well be helpful for the budget debate that's going to come next week, I think. If you just give me a second, members.
You don't need that. Just in case you wanted to.
I just wanted to be sure. All right. Item 14 then is an invitation from Thrive to attend a conference on the 4th and 5th of June at Stranmillis College on what is described as innovative and collaborative approaches to tackling the impact of poverty on children and young people. And that's at pages 242 of the meeting pack. Members, you're asked that if you wish to attend that conference, you could book your place directly via Eventbrite and not through the committee itself. Are members content to note the other items of correspondence set out in the memo, or do you have any comments on anything else? No? Thank you. Agenda item 13 is the chairperson's business, of which there is none. Agenda item 14 is any other business. Does anybody have any other business? No? Thank you. In that case then we'll move to the date, time and place of the next meeting, which is going to be next week, Thursday the 30th of May at 2 p.m. in this room. Thank you very much, and the meeting is adjourned.
Committee Room 30, sound.